We are live.
All right.
We're here with Philip Den Heever. Have I pronounced that properly?
You have pronounced it right, Simon. Great to be with you, mate.
From Frank Law up in Sydney, positively tropical compared to Melbourne, where it's a frosty Wednesday morning. Mate, thank you so much for joining us.
Pleasure, mate. Thanks for the opportunity.
The way we always start is asking people to just give us a quick 1-minute pitch, so the heathens and the uninitiated who are watching this, who don't know you, tell us what you do.
Yeah. Good day. Yeah, thanks, Simon. Look, I'm a commercial and employment lawyer from Frank Law. We're a firm based in Parramatta, up here in Sydney. We specialise in corporate advisory and litigation matters, which, of course, we say employment law is part of that. We also have a small team of family lawyers who looks after personal law. We're about a team of 14, 15 people. And it's been absolutely fantastic to be with you this morning. Thanks, mate.
Nice. Thank you. So I think some of the stuff that we're keen to just get your opinion on, and we'll caveat this whole conversation with, this isn't legal advice. This is stuff that any viewers should be thinking about. So we'll caveat that straight away. Yeah. This crazy situation we're in at the moment, these weird times have forced us all to start working remotely. But I think a lot of the conversations that we hear from customers that we deal with now, and prospects that we're talking to, sort of center around, hey, we've all got used to working remotely. We kind of like this, and we think we can make it work. And we're now thinking of hiring distributed teams and leveraging talent from across the globe. And it sounds great in theory, and some of the dialogue that we also have with customers is around geographically bound talent pools are limited for obvious reasons. So whilst everyone thinks it's a great idea and they should be leveraging overseas talent or distributed teams, there's obviously some very real things and risks that they need to sort of be aware of. And I think that's the sort of stuff we were hoping to get your opinion, not your legal opinion, just your general opinion on today. And I think sort of the first thing to ask you is, let's assume for a second that you've interviewed someone from overseas. You want to employ them as a full-time worker overseas. You have an employment contract. Is that legally binding potentially in their country, or should you be using a contract from the country that they live in?
Yeah, that is a great question. And I think employers needs to be generally careful how they go about that, and particularly the reasons why they do that. Simon, most employers, I would have thought, Australia has a generally high minimum wage structure and entitlements, which kind of, incentivize people to actually employ from overseas. So they think that there are benefits to employ people from overseas. Now, if that is not done correctly, they could actually create a situation where that employee, even though the work has been performed overseas, could be also subject to the Fair Work Act and the minimum entitlements that are applicable here. I think what's important to know is that the law clearly says, the Fair Work Act clearly says, an Australian employer, in other words, that is a constitutionally corporation that is in Australia, the Australian set up in Australia, who employs people overseas, will be subject to the Fair Work Act. So there are certain ways, obviously, that you can deal with that and manage that. So that is the first thing to know. What I sometimes hear people do is they say, well, all right, we will set up a company in the other country, a subsidiary or something like that, and we will employ through that subsidiary. It will be a company that's registered in that country. That law will apply. And then they usually say, we will put in that employment agreement that the laws of that country applies.
Yeah.
Now that sometimes works, but there are occasions where that doesn't work. The law clearly says if there's a significant connection with Australia, clauses like that will not work. It is about the relationship and whether the employment relationship is sufficiently connected to the country to which laws which will determine which laws will apply. So I don't know whether that answers your question in a sense, but so yes, there are ways that it can be managed, but people need to be very careful if they think that they can get the benefit from offshoring work by simply issuing an Australian-based employment agreement and say, there you go. Yeah, there are certainly risks involved in doing that.
Yeah, gotcha. I'm going to guess that certain countries would probably carry more risk than others for Australian HR teams.
Yeah, I mean, then add on top of that, you need to consider the laws of the country in which you are employing as well. They will have certain regulations and so forth that are also might be binding on you as an employer that sits over here, especially the European countries. They have very favorable, I would suppose, employment terms. I'm talking about, I don't want to go into details, but about medical insurance, maybe high annual leave entitlements, sick leave entitlements, just entitlements which are not necessarily entitlements that we in Australia would be entitled to. So there are certainly, and of course, those countries' laws would also look at this employment agreement and go, wait a minute, the employee would go, maybe I'm a bit more entitled to over here. Maybe I should see if I can get something out of this country if the laws are more favorable. You mentioned unfair dismissal or dismissal and whether that is unfair and whether employment is terminated. I think that will largely depend as well on the country in which that employee is based. Again, Australia has very, I would say, favorable employment termination provisions and laws that governs when employment can be terminated. Other countries, it is quite easy to terminate somebody's employment and with very little, if any, repercussions. So, these are all factors that should be considered before you structure the way in which you engage employees overseas. I suppose that would be my advice to your clients, is that they should seek advice about how to structure it, because it needs to be properly structured, and it depends on the country in which they wish to engage people in, I suppose. There are different ways that it can be dealt with that makes it more effective and for an employer, which limits risk. But it needs to be considered on a case-by-case basis.
Yeah, absolutely. And I think the case of the dismissal is an interesting one. If you have somebody overseas who potentially isn't performing, and the person that they report to, their hiring manager, feels that they've done all they can to try and get that relationship back on track, but it's just not going where it needs to go. In the States, for example, I know in some states in the US, you can just terminate straight away.
That's right.
But here you can't. So
the
potential there is for hiring managers or for team managers to treat one group of employees one way because they know they can terminate them straight away, and maybe home-based employees a different way, which then obviously has potential for danger. I think the other thing that people must, I think you hit it on the nail, especially if you start to employ in different jurisdictions where different laws apply, where you think you might, as you say, treat one employee one way and another employee you treat the same way on the assumption that you're entitled to do that, where in fact you might not be. I mean, even the Fair Work Act, we must remember, under Section 550, I think, places certain personal liability on decision makers and HR professionals that makes this decision in businesses. They could be personally held liable for penalties and so forth should they in any way take adverse action or some other action where if they assume the other country's laws apply and not the Australian laws apply. So there are certainly risks involved in employing people from overseas and assuming that home country's laws will apply and not Australia's law. Absolutely. Yeah, and I think you're absolutely right. I think double checking, being very sure about what you're getting yourself into, really important. I don't think anybody wants to be the HR manager who has to go to the CEO and say, "Hey, we've got a big problem," and I think it's kind of my fault because we didn't do our homework.
Absolutely, and I also think people need to understand that the case law is quite clear. That it is not where the work is performed that is the critical point of which jurisdiction applies. It is to what extent is the employment relationship connected to that country?
Right.
So the court will look at, is the person, for example, there's many things the court can look at, but one of the things, or some of the things they might look at, is the currency. What currency are they paying? Where do they pay taxes? Right? Who do they report to? Do they need to attend an office? Do they need to sign on somewhere? These are the type of things that the court will look at the entire relationship to determine, is there sufficient connection with that country to that laws will apply. The other important thing is public interest. That is another consideration for the court. Is it in the public interest that the laws of one country apply over another one? And let me give you an example, if I may. There's a New Zealand case where these New Zealand pilots, well, not New Zealand pilots, they flew for Cathay Pacific in Hong Kong. They were employed under Hong Kong laws and everything, but they were based in Auckland. So they would sign on in Auckland, fly to Hong Kong and back and back and back, and then sign off at Auckland at theirs. They were residents of New Zealand, not Hong Kong.
Yep.
That is, again, another important consideration. Is the person a resident of the country? And the court ultimately find that and they had one of their terms of the employment contract said that you must retire at 55. Now, in New Zealand law, that is discrimination. In Hong Kong, it is not. So the court said, look, I've looked at all the circumstances, and I've looked at the entire employment relationship, and I've determined that New Zealand law apply. However, even if that was not the case, it is in the public interest that people are not be discriminated against based on age. Therefore, New Zealand law applies not. So they've deemed discrimination such a critical thing in the public interest that they said, no, Hong Kong law doesn't apply, New Zealand laws apply. So those are the two considerations. It is the relationship as a whole. Is it sufficiently connected to one country or the other? And the second thing is, what is in the public's interest?
Super interesting. One other one for you, and it might not be your area of expertise, but I think it's worth asking. One of the other risks, obviously, you hire someone, or a business hires someone, let's say in the States, because we'll be talking about it. You may not have ever physically met this person. You've probably done a whole bunch of these sorts of discussions. So I think one, actually verification that this person is who they are and has work rights in the States, all that's really important. But from an information security perspective, you onboard this person, they're getting access to all your systems, potentially sensitive information. If you're publicly listed, there's a whole bunch of other sort of implications there. What's a legal position on that? Is there?
I suppose like most lawyers will tell you, is that you need to have your confidentiality and privacy protection documents and paperwork in place. Make sure that you do your checks and balances. The reality, however, is that you can only do so much, and you need to be careful. Think about your risk in trying to enforce these agreements. It's one thing to have these agreements in place. It's another thing to say, well, I might have to go to the US to have this agreement actually enforced against the person, because even if the person is still living over there, and I get an Australian court order to do whatever, prevent the person from spreading information or whatever the case may be, it is difficult to enforce Australian orders in foreign jurisdictions. It's not an easy thing to do, one, and secondly, it's very costly. It's very costly. So it all costs you money. So that is certainly a consideration that must be taken into account before you engage people from overseas. I also think that you need to think about your systems and processes when engaging people overseas in terms of who is allowed what access to information. The reality is having somebody in your office with who you have a personal relationship, engaging, talking with, it's much easier to trust and allow certain information than somebody that you've never met, on the example that you've given, and just give them carte blanche access to your processes and your systems and your clientele and so forth and so forth. So I do think that there needs to be strict processes in place to protect your sensitive information on a need-to-know basis to those employees who are not based in Australia, because you know that whether you have an employment agreement based in Australia or in America, enforcing those protections that you have in place are going to be problematic and costly. So certainly that's an added risk to your, to doing what you want to do. So, perhaps it's not great to appoint an accounts lady in the United States, accounts person, in the United States to do your accounts and have access to your accounts. The risks are just, perhaps too much.
Yeah, absolutely. So there's a whole bunch of things that need to be considered and need to be, given sort of careful thought and investigation into. Anything we haven't spoken about that you particularly wanted to raise? I
think the other issue, which is quite an interesting dynamic, is if you engage them as a contractor. Because as you and I know, engaging person as a contractor or employee, the lines are so blurred there as it is. And of course, the courts do apply what we call the multifactorial test. There's not one single aspect of that relationship that determines whether it's a contractor or not. The court looks at the overall relationship as a whole and trying to determine, was this a contractor relationship or employee relationship? So then you throw into that little basket the foreign jurisdiction aspect, and it becomes a really complicated issue. That is something that all needs to be considered. Now, it could be a very clever tactic to use a contractor overseas to avoid difficulties with employment law, but at the same time, it could cause you a lot of headache, which you perhaps didn't consider before. So again, there's ways to deal with these things, but they need to be considered on a case-by-case basis. And as you've said, even if you do that, it's the ongoing relationship and managing of that relationship that also has to consider, what am I supposed to do? What's my rights and entitlement? What's the employee's rights or the contractor's rights and entitlement in the country where they are based? What that I should take into consideration.
Yeah, beautiful. Fantastic, mate. Covered a lot of ground this morning. It's been.
I hope so. Let me know if you need anything else. Look, it's a very interesting part of the law, and it's no case is the same.
No. So I think the washout from this discussion then is distributed teams can be a good thing, and embracing new talent and all that can be a great thing. But there's a whole bunch of things you need to consider. Don't rush into anything. Ask a professional if you're not sure.
Yeah.
Here.
Sure.
And I think take your time making decisions. Don't rush into anything.
Yeah, I think that is absolutely right. The benefit that you think you gain might not be the benefit at all.
Yeah, beautiful. Mate, thank you so much. Absolute pleasure to chat to you this morning. Where can people find you if they want to talk to you?
Yeah, sure. People can find me on www.franklaw.com.au is our website address.
Yep.
My email, I'll give my email address. It's Philip with 1L at franklaw.com.au.
Beautiful, and I'll put those in the comments as well. Mate, thank you so much. Absolute pleasure talking to you. Nearly 10 o'clock. Got the whole of the rest of the day to come.
Thanks, mate. Have a good day. Cheers.